This application for leave to appeal against sentence concerns the sentence imposed on the applicant, Eddie Ratcliffe, on the 2nd of February 2024 at Manchester Crown Court after he was convicted on the 20th of December 2023 following a trial, together with his co-defendant, Scarlett Jenkinson, of the brutal murder of Brianna Ghey. Brianna was only 16 years old when she was killed. She had her whole life ahead of her. She had some struggles that made her vulnerable, but she was supported by a loving family who wanted nothing but the best for her. She made a real impact in her short life, and her family remember her for her laughter, for being full of life, and as a good listener. Mrs. Justice Yip sentenced the applicant to be detained at His Majesty's pleasure with a minimum term of 20 years, less time spent on remand in custody. Scarlett was sentenced to be detained at His Majesty's pleasure with a minimum term of 22 years, less time spent on remand in custody. The judge identified as mitigating factors the applicant's age and level of maturity, which was less than many others of his age, his previous good character, and his progress in detention, good behaviour, passing GCSEs, starting to study for A-levels, and starting speech and language therapy. Having considered the many reports about him, the judge concluded that his thinking skills were less developed than normal in several areas, but that his diagnosis of ASD and associated limitations did not significantly lower his culpability for Brianna's murder. She took into account, however, that his experience of custody would be made more difficult by his ASD, his severe anxiety, and his selective mutism. The judge found that the applicant's culpability was not quite as high as that of Scarlett, and that the aggravating and mitigating factors in his case were evenly balanced. It was therefore not necessary to make any adjustment to the starting point of 20 years for the minimum term, other than to deduct the days spent on remand in custody. The respondent argues that the judge had heard the trial and seen Scarlett and the applicant give evidence. She was in the best position to assess their differing roles, and the sentence that she imposed on the applicant was correct for the reasons that she gave. The applicant was fully aware of this and actively participated in a brutal murder which must indeed have caused Brianna to suffer before she died. In those circumstances, the judge was entitled to conclude that the applicant took part in a murder involving sadistic conduct. This was a joint enterprise. Further, the judge found as a fact that the murder was partly motivated by such hostility, transgender hostility, on the applicant's part. This court will not interfere with a finding of fact made by the sentencing judge unless the court is satisfied that no reasonable finder of fact could have reached that conclusion. For these reasons, we conclude that the sentence imposed by the judge on the applicant was neither manifestly excessive nor wrong in principle. The proposed grounds are not arguable. The applicant's application for leave to appeal against sentence is refused.